Hello, my name is Aine Flynn and I'm Director of the Decision Support Service. In the following presentation, I will outline the potential considerations for families and carers in relation to the Assisted Decision-Making Capacity Act. This presentation looks at the main principles of the Act, the practicalities of the new framework for supported decision-making, and the interactions that families and carers might have with the Decision Support Service. In this presentation, we are looking at some of the considerations for carers that might arise in relation to the Assisted Decision-Making Capacity Act of 2015 and the functions of the Decision Support Service. The Act commenced as operative law on the 26th of April 2023, and on the same date, the Decision Support Service began to operate all of its functions under the Act. Just thinking about some of the key principles of the 2015 Act and the reforms which it introduces. The Act is about how we support people to make their own decisions as far as possible. And some of the key reforms which the Act introduces are that it abolishes the wards of court system for adults. It sets out a functional approach to capacity. So that is the way that capacity is assessed if it needs to be assessed. It contains important guiding principles. It introduces a new framework of formal decision-making supports where those are required, and makes available new tools for advanced planning, and then establishes the Decision Support Service with our roles and functions. The Act applies only to persons over the age of 18. Thinking about the old law, the Act abolishes wardship, as we have said, under an old law called the Lunacy Regulation Ireland Act of 1871. Under wardship, the court, usually the High Court, can declare that a person is of unsound mind and incapable of managing their affairs. When the Wardship Court makes somebody a ward, the court moves into that decision-making role and appoints a committee, usually a person in the life of the ward, sometimes the General Solicitor for Wards of Court and Minors, who is authorised then to take the day-to-day decisions. So usually a person is taken into wardship or has been in the past for a particularly significant decision, such as the award of compensation. But the effect of being made a ward of court is that they are no longer able to take some unrelated and even quite minor decisions which obviously mattered to them. These could be decisions like choosing to travel abroad or consenting to routine health care. So adult wards, and there are about 2,200 of them, will all now have their cases reviewed, and that has to happen within 3 years. A ward or their committee or another person on their behalf is able to initiate that application in the Wardship Court. Either way, the Office of Wards of Court, who is responsible for this process, has to ensure that everybody has their cases reviewed and exits wardship within 3 years of the 26th of April 2023. So the DSS isn't involved in this process. And if you are a ward or caring for a ward or know somebody who's caring for a ward, and if they want more information about this process, that information is available from the Office of Wards of Court, and the DSS can point you in the right direction if need be. I mentioned the functional approach to capacity. So this approach asks, do you have capacity to make a decision at the time when you need to decide? It's a time-specific and issue-specific approach to capacity. So whereas in wardship, the person could be declared to be a person of unsound mind, under the functional approach, it always hinges on the particular decision that you need to take. And the functional assessment is not a medical test. It's not concerned with the person's diagnosis. Sometimes I'm asked, well, is this an act for a person with intellectual disability? Is it an act for a person with an acquired brain injury? And it could be. It could be that people who experience difficulties with their decision-making because of those reasons would benefit from the Act and the new supports under the Act. But the Act doesn't speak at all about what a person's diagnosis might be. The Act also doesn't use the words mental capacity at all. As we sometimes say, you lack capacity is not a full sentence. It's always capacity to decide a particular thing at a particular time. And this is already the law. We have law that is made in the Oireachtas and we have law that is made in the courts. And the courts have already said that this functional approach is the correct approach when capacity needs to be assessed. And the court said that as long ago as 2008. So what are the elements of the functional test? Well, thinking about the particular decision that a person might need to take. Does the person understand the information relevant to the decision? Are they able to retain that information for long enough to make a voluntary choice, use or weigh up the information, and then communicate a decision? And that means communicate with appropriate assistance if necessary. As you will know, people have their own particular requirements around communication. They may need sign language, assistive technology. They may just need the support for communication of the person who knows them best. And those tools for communication should be facilitated. And the fact that a person has those communication requirements doesn't indicate that they lack capacity. So if a person is unable to do all of the above, then the conclusion can be that they lack capacity in relation to the particular thing to be decided. These are some terms that we use. So relevant person is a term which is in the Act, and that is the person whose capacity is in question or may soon be in question. Or at B, it may be that they have been found to lack capacity in relation to a decision or decisions. And you see also how the Act recognises that a person could be in A and B at the same time in relation to different decisions, or there could be other decisions entirely in relation to those. They're not a relevant person at all. Decision supporter is a term that we use in the DSS to mean these new agents or personalities under the Act who are able to supply support in different ways. And if I say decision supporter, I mean all of them. And if I mean only one, I'll tell you which one we're talking about. The Act contains important guiding principles. And the first of these is already law also because the courts have said so. And this is the presumption of capacity for adults. So an adult is presumed to have capacity to make a particular decision, presumed until the contrary is shown, and if it is to be shown, it's shown in the functional way that we have just looked at. So this is the case already, and the Act is just putting into black letter law what is already the legal standard. It means that if somebody has an intellectual disability, you can't look at them and decide that they don't have capacity. The starting point is that they are able to decide unless the contrary is shown. And related to that is this principle that a person is to be supported as far as possible to make their own decisions. An unwise decision doesn't mean that a person lacks capacity. Now, that's not the same as saying that everybody has an unlimited freedom to be unwise. None of us does. But rather that having decided to do an unwise thing or wanting to do the unwise thing, it doesn't mean that you lack the capacity to decide to do it. The Act emphasises the importance of doing as little as necessary to interfere with a person's rights and freedoms, and always having respect for their dignity, privacy, their autonomy, and their right to control over their own money and property. People should always be encouraged and permitted to participate as far as possible in any intervention that concerns them. There are also principles around considering the views of others. So that would include carers. When making any intervention under the Act, it's appropriate to talk to the people closest to the person. I've put the next one in bold. It's considered very important under the Act and it's mentioned at different places in the Act. And this is the principle of giving effect as far as practicable to a person's past and present will and preferences. The United Nations Committee on the Rights of Persons with Disabilities have emphasised the importance of respect for will and preferences over a best interest standard. The United Nations Convention on the Rights of Persons with Disabilities was ratified here in Ireland over 5 years ago in 2018, and that convention says that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. So there is no reference to best interests anywhere in the Act. The starting point is not what is good for a person, but rather what do they want to happen, at the same time always acting in good faith and for the benefit of the person. And what sort of decisions are capable of being supported under the Act? These are broadly divided into two categories, so that there are property and affairs decisions and personal welfare decisions. And property and affairs decisions are anything to do with owning, buying, selling property, potentially making a gift of property, although there are certain exceptions in the Act about making gifts, carrying on or winding up a business, paying debts, which could include revenue liabilities, providing for other persons, involvement in court cases, applications for benefits. And personal welfare is also very broadly drawn: accommodation, education and training, social services, healthcare, which can include decisions about medical treatment. Participation in research has now been added to that by the amending legislation that was passed last year. And you see here the very broad other matters relating to the relevant person's well-being. So those are all the sorts of decisions that are capable of being supported under the Act. And there are certain decisions that are specifically not capable of being supported under the Act. And in relation to these, the Act says that there is no change to the current law in relation to capacity and consent. This means that a decision supporter cannot be involved in decisions about matters that include decisions about getting married, decisions about separation or divorce or guardianship, or placing a child for adoption, consent to sexual relationships, or serving on a jury. So those are the decisions that are capable of being supported, and the limited number that are not capable of being supported under the Act. And this is the new support framework for people who require it. Can I emphasise here that the fact that somebody has these decisions to make does not mean that they suddenly need to be slotted in somewhere on the new framework. Remember that adults are presumed to have capacity, and remember also that they are to be supported as far as possible to make their decisions. And in approaching this Act, I think it's useful to say, think about the decisions and think about the other person involved in that decision-making process. What are they saying? What is your interaction, for example, with somebody in the bank or a healthcare provider? What are they saying about the person's ability to make decisions? So let's not assume that everybody has to fit in somewhere on the new framework, but this framework is offered and it's available to people who may benefit from it. So at the lowest tier you have the decision-making assistant, in the middle the co-decision maker, and at the top tier the decision-making representative. All have to apply the guiding principles, remembering respect for will and preferences. And who can be a decision supporter? In formal arrangements under the Act, ideally the decision supporter will be someone close to the person and in a relationship of trust. The Act sets out certain grounds. On these, a person would be ineligible to be a decision supporter, and these include criminal convictions for offences involving the person or their child, a history of safety orders or barring orders, in some cases bankruptcy and insolvency, and this applies if the decision-making is about property and affairs decisions. Or if the person is in a designated centre, residing there or in a mental health facility, then the owner or a registered provider or the employee of that service is not eligible to step in and be one of these decision supporters. So let's look at 3 decision supporters in turn. And the lowest and least formal one is the decision-making assistant. And sometimes people ask us, how do I become my loved one's decision-making assistant? Important to say that the appointment is being made by the person who considers that his or her capacity is or may shortly be in question. So it has to be their idea with their agreement, if you like. The decisions that they're going to get assistance with are then set out in a decision-making assistance agreement. And what the decision-making assistant does is practical but quite limited support. They're helping to obtain information, helping the person to understand that information, helping the person to communicate their will and preferences, to make and express decisions, and also helping to ensure that the decision is implemented. So these could be the decisions that we've looked at already, decisions about managing bills, decisions about healthcare. Really, it's a formal arrangement which allows the person to have access to the information and to play a role in explaining it and helping the person to communicate what they want. No capacity assessment is required, and this decision-making assistance agreement is notified to the DSS so that we're able to confirm that a person really is a decision-making assistant. It's not registered in the same way that applies for some of the other arrangements, but it means we're able to confirm that somebody really is this decision-making assistant. So the person is still making their own decision. Important to say that. At the middle then, in the middle tier, we have the co-decision making agreement. The appointment comes about in the same way, so that here is a person who considers that his or her capacity is or may be in question, and they're choosing somebody who is a relation or friend in an established relationship of trust and drawing up a co-decision-making agreement, so that they're now going to take specified decisions jointly. And this comes to us for registration. Notice parties may object to registration, so there's an opportunity for other people who are close to the person to intervene and object, and they can object on specific grounds. A formal capacity statement is required, and character references are also required, together with other documents. A co-decision-making agreement can be varied or revoked over time. It can't include decisions about making gifts. And a co-decision maker provides advice by explaining relevant information, helping the person to communicate their will and preferences, looking at the options and likely outcomes. But what is different from the lowest tier, importantly, is that they are making decisions jointly, and the co-decision maker helps to ensure that these decisions are implemented. The DSS keeps this under review, so we have to conduct periodic reviews of the co-decision making agreement, and we will require an updated capacity statement each time. The co-decision maker keeps records and submits annual reports to the Decision Support Service. They can claim expenses but not remuneration. We have standard forms for the reports that the co-decision maker submits to us, and we can help with the provision of information, and generally our intention is to support the supporter. At this level, the person's capacity is that they have the capacity to appoint the co-decision maker. They need the particular assistance that a co-decision maker can provide, and then together with the co-decision maker, they're able to make the specified decisions jointly. So again, not all decisions, just what is covered in the co-decision making agreement. At the top tier of support then, there is still the route to court. And this is an application to the Circuit Court. Wardship was mostly in the High Court. The DSS is not involved here, except in a particular way if there is nobody to become a decision-making representative. And we might be involved as an outcome of the application, but the application is made to court, not to the DSS. And this is an application which can be made by any person with a bona fide interest in the welfare of the person, a family member, potentially a service provider. And the applicant is asking the court to decide if the person has the capacity to decide a particular thing or things. So it is a particular matter or matters, and this will be set out in your application form to court if you're bringing an application. The court will require a report in relation to capacity, and in general, to find out more about how to bring one of these applications, you are looking to the Courts Service. There are forms which you can find on the Courts Service website. And if anyone needs any guidance on how to access these, a link to the information is available on our website. Anyone applying to court again has to notify other parties, including the spouse, the partner, any adult children of the person. There is provision of legal aid to the relevant person here and to the applicant. Remembering those guiding principles, they apply to the court as well. So the court has to think about the least restrictive option. The court has to ask if anything else has been attempted, because court should really be the last resort. The court can make the decision for the person and is perhaps more likely to do that if that's a once-off isolated type decision, or the court can appoint a decision-making representative. This could also be the outcome of the review of a ward of court, the appointment of a decision-making representative. And when the court is deciding about its decision-making representation order, the court has a number of matters to consider, including the will and preferences of the person, the compatibility of the relevant person with any decision-making representative who is now being proposed. The court has to think about existing family relationships, the desirability of preserving those relationships, the potential which can arise for any conflict of interest, and also the court has to think about the complexity of the particular piece of decision making. Is that going to require any particular expertise, and will that expertise be available to the proposed decision making representative? So here's where the DSS might become involved. If there isn't anybody who is suitable or willing and available to act as the decision-making representative, the court can ask for nominations from our panel of professionals. So these are suitably qualified, fully vetted and trained registered professionals. About half of them are lawyers, about 25% are social workers, and they're available to be nominated to the court, and the court can choose somebody to act. Important to say that even if a panel member is appointed rather than a family member, then the panel member DMR is required to consult with carers, with those closest to the relevant person. The court can appoint more than one decision-making representative. It might do that. It might appoint, for example, a panel DMR in relation to certain matters and a family member DMR in relation to others. Or it can appoint more than one DMR in relation to the same matters and say how they are to act together. The decision-making representation order is intended to be limited in time and scope, so it isn't about deciding everything and deciding for all time. And just staying with the decision-making representative, so they're taking their authority from the court order, and particular restrictions apply. A decision-making representative cannot make decisions about life-sustaining treatment. They cannot stop another person from seeing the person. And the Amendment Act has removed any references to restraint by a decision-making representative. They are acting as agent, if you like, making decisions and acting as agent to ensure that decisions are carried out. They still, however, have a duty to ascertain and assist with the communication of a person's will and preferences. And the decision-making representative, like the middle-tier co-decision maker, comes under our supervision and submits reports to us. The court may make authorisation in relation to the claiming of expenses, and that's all provided for under the Act and regulations. The Act provides two tools for planning ahead, which is something that all of us should think about doing. And the first of these is the enduring power of attorney. So this happens when an adult who has capacity formally appoints a trusted person in their life, called here the attorney, but that doesn't mean a lawyer, just somebody that they know and trust, to take decisions for them in future if that becomes necessary. Enduring powers of attorney have been around for some time, and an EPA under the old Powers of Attorney Act of 1996 is still valid. If somebody makes a new EPA after the 26th of April 2023, then they're making a 2015 Act EPA, and what is new is that the attorney appointed under that Act is supervised by the DSS and submits reports to us, like the co-decision maker and the top-tier decision-making representative. They are turning in reports. Some changes have been made in the amending legislation that was passed last year, so it isn't possible to include treatment decisions in your enduring power of attorney. And there's a new two-part process, so that when an EPA is made under the 2015 Act, it is sent to us in the DSS for registration. And then the second step is the notification to the DSS when that enduring power of attorney needs to come into effect. The other important tool for planning ahead is the Advance Healthcare Directive. So again, an adult with capacity is able to plan ahead in relation to the treatment that they want and don't want. It allows them to set out their will and preferences and to provide healthcare professionals with important information about their treatment choices. They may appoint a designated healthcare representative to be their agent, so this is our fifth decision supporter. And like the enduring power of attorney, the Advance Healthcare Directive only becomes effective if the person lacks capacity to make the decisions for themselves. A refusal of treatment contained in an AHD is binding, and this can include life-sustaining treatment. It can't include refusing basic care. You can't plan ahead and say, if I can't say this for myself, then I don't want, for example, ordinary oral hydration or nutrition. That wouldn't work. And an Advance Healthcare Directive does not require to be registered to be valid. Important to say that although the Act says that the Minister may make regulations for the DSS to hold a register of Advance Healthcare Directives, those regulations haven't been written yet, so we in the DSS don't at this point in May of 2023 have a register of Advance Healthcare Directives, and that may change in time, but it will never be the case that an AHD requires registration in order to be a valid document. A word about next of kin and what it really means, and we have other information on our website on this point. There is, I'm afraid, an incorrect belief that the next of kin, so-called, already has a legally recognised role as a decision maker. So there's a widespread belief, understandably, because the term is used widely, that the spouse or partner or adult child or the child of an adult person already has a legally recognised role to share in information, to make decisions, to give or to withhold consent. This has never been the case, and it isn't just that the next of kin doesn't have this role or authority, but rather that no adult is authorised to decide for another adult outside of a legal arrangement, and those arrangements pre the 15 Act could only be by way of enduring power of attorney or as a committee in wardship. So the Act hasn't done anything new here. And I've just mentioned in this slide the results of a survey conducted by Sage Advocacy 5 years ago, which shows how widespread that belief is. That doesn't mean that the family is being sidelined here. As we've been seeing, the family may very well be the person best placed to step into one of these formal decision-making roles. And even if they don't, if somebody else has taken on that role, there is still a requirement to consult with family. The Decision Support Service is a new independent statutory service established under the Act with a range of functions primarily to promote, to register arrangements under the new framework and to supervise the performance of those arrangements. We are located in the Mental Health Commission. We have separate functions from our Commission colleagues. The Mental Health Commission has its functions under the Mental Health Act, and the Decision Support Service has its functions under the 2015 Act. And these include broadly to promote public awareness and confidence, providing information to relevant persons and their supporters, and to organisations that may need to interact with the relevant person and with supporters. We will register and supervise decision support arrangements under the Act as set out. And we have panels of persons to help with functions under the Act. I've mentioned our panel of decision-making representatives who are available to be appointed to court, and we also have special visitors and general visitors, and they are experts on our panels and they help with supervision and investigation. There will be codes of practice. There are codes of practice already published to provide guidance. And we review the operation of the Act and report back to the ministers. Looking at the investigation of complaints, we can take complaints by any person about a decision supporter or a decision support arrangement. We don't take complaints in any other contexts. And the grounds of complaint could be that a supporter is acting outside of scope, or that they are unsuitable, or that here is an arrangement which is not in accordance with the person's will and preferences. It could be an allegation that fraud or coercion or undue influence has been used to try to compel the person to enter into the particular arrangement. The complaint could relate to the person's capacity issues. It may be an allegation that the person's capacity isn't what it requires to be, for example, to have a co-decision-making agreement in place. Or the allegation could be that the decision supporter is breaching a function under the Act, or perhaps not acting in accordance with the guiding principles. And in response, we can do a number of things. We can summons witnesses, take up evidence, we can apply to court for a determination. We might have to go to court on an interim basis. That means while the investigation is ongoing, we could have to suspend the decision supporter from acting if we think that real harm is going to result if we don't. We can conduct own initiative investigations, and we are able to resolve complaints informally, which is something we hope to be able to do more often than not. So again, these are complaints just about decision supporters or decision support arrangements, not about anybody else. I mentioned our codes of practice which have been published, and there are 13 codes in total at this point. These include a general guidance code on supporting decision making and assessing capacity, guidance for all of the categories of decision supporters. And these were the subject of a public consultation before they were eventually published with the approval of the ministers just before commencement in April of 2023. Any person shall have regard to a code of practice when performing a function under the Act, in respect of which the code provides guidance. And these have been published on our website, which is where we'll find them, together with a number of how-to guides, a document that provides guidance in a simplified way to each of the codes. This is what we don't do. The DSS doesn't make decisions for people. We never have that role, even as a last resort. We can't directly appoint decision supporters. We do have that panel of top-tier decision-making representatives available to be nominated to the court and appointed by the court. But we aren't authorised to find for people co-decision makers, for example, or attorneys. We do not have a function to manage money and property. We don't provide legal advice, we provide information, in some cases information and guidance. And as I've been saying already, we don't have a function to regulate other professionals or services. So these are just some of the considerations that potentially might arise for you if you're caring for a person and wondering about what the Act could mean for you. As I've said already, and I think it's an important point to make, the Act doesn't say that anybody has to enter into one of these new arrangements. Again, that's going to depend very much on their circumstances and the decisions that they need to take. And certainly it hasn't been intended that carers will have to apply to court to become DMRs to manage everyday decision making. Think about perhaps how decision making is being managed now, and as I was saying, who are the professionals and the other services involved? What are they saying about how decision making is to be managed? The DSS will be involved with individuals and their families only in relation to the formal arrangements under the Act. Although clearly you can come to us with queries at this stage, and we'd be happy to provide information. Or if there is any particular difficulty in the interaction that you're having with third parties, perhaps we can do something to provide information and guidance in the way that the Act permits. Interaction with the DSS, so registering arrangements with us or filing reports with us or raising objections, any of those interactions will primarily be on our digital platform. We have a customer portal set up on our website, but of course there have to be workarounds. That way, if speaking to the DSS won't suit everybody, so there are alternative processes available. But we hope that the digital interaction will work well, and we have tested that. There are fees that apply to certain applications to the DSS, and these are set out in regulations, and the biggest single fee is one of €90. €90 applies for the registration of a co-decision making agreement or the notification to us of an enduring power of attorney. Nothing is more expensive than €90, and we are also authorised to waive fees entirely on a means tested basis. It's quite a simplified means test. There are no fees for turning in reports to us, so if you become a decision supporter and you're supplying those annual reports, no fee arises there. And as we have been saying, legal aid is available under the Act. It's available in a general way to most of the parts of the Act, and more information will be available from the Legal Aid Board about how to qualify for and access legal aid. And we can again point you to the right direction if need be. Thank you for viewing this presentation. You will find more information elsewhere on our website, including frequently asked questions, the codes of practice, and guidance on all aspects of the legislation and the services of the Decision Support Service. You are also welcome to call our Information Services team on 01 211 9750 or email us with any query you may have at queries@decisionsupportservice.ie.